The gentleman has long since expired. The Chair now recognizes the gentleman from Arkansas, Mr. Hill.
Thank you, Mr. Chairman. Thank our panel, and I particularly want to thank Ambassador Gray. I certainly think of a hallmark of my career as our service on the White House staff for President Bush 41. And thank you. I know you look back fondly this summer with the commemoration of the Americans for Disability Act that you were such an instrumental leader on in having that passed in the Congress. Chairman Royce was talking about the consumer protection rules were basically under the guidance of the prudential regulators. And for me, that's no academic exercise, for I was a CEO of a consumer and commercial bank until December 31 of 14. So this hearing, Mr. Chairman, is no academic exercise to me. I have run an institution under the first 5 years of Dodd-Frank, or 4.5 years. And to me, the CFPB really was a redundant exercise, and let me explain why. Because I never once, in over 2.5 decades of commercial banking, ever saw a state or federal regulator shirk their consumer protection responsibility under federal law. So I want to repeat that every hearing, that is a way I feel very, very strongly. And I heard today from both Mr. Green and the ranking member that where Dodd-Frank has gone too far, we should work in a bipartisan way to amend it, mollify it. I couldn't agree more, and I'd like to thank Mr. Chairman and our bipartisan group that are working to take care of one of those things right now, which is this new HUD-1 RESPA form, the TRID form, and trying to get bipartisan support here in the House and the Senate to remove the penalties in the implementation of that act. Mr. Cordray has refused to do that in his own authority at the CFPB, and we've now had to ask Congress to delay the possible penalties to players on that rule of the CFPB. And, you know, I want to side with the consumer here. Some 230,000 Americans refi or buy a new home every month, and they're going to be the one who are victimized by this confusing rule that doesn't get implemented properly, either due to a technology reason or a misunderstanding at a real estate brokerage or a title company or a bank. So I hope we can get this bill passed before October 3rd so that our title and commercial banks, mortgage bankers, real estate agents all have some confidence that they can go into this new closing regime but not be penalized either by the federal government or through civil liability. And I want to thank Mr. Sherman and certainly Mr. Pierce for their help on this committee, and you, Mr. Chairman. We can't defend bureaucratic intransigence at the expense of our home buying public. I love this hearing on the rule of law. It's exceptional. I thank the Chairman. I want to echo appreciation for it. And I want to turn to Mr. Gray and Mr. Skeel. You know, the missing man in this formation, you know, when the airplanes fly over the funeral, the missing man formation, sort of in the Dodd-Frank Act, the missing man is reform of the GSEs, Fannie Mae and Freddie Mac. Mr. Gray referenced equal treatment for privately or similarly situated creditors. You were referring, I think, to GM in your testimony, but I think that might apply in the Fannie Mae and Freddie Mac conservatorships. And Mr. Skeel, you talked about the 100% sweep that's now in place between Treasury on Fannie and Freddie, the so-called Third Amendment to their conservatorship. It struck me that that may not even have been a legal action given the conservatorship statute. I'd like both of you to address that. Ambassador Gray, if we could start with you.
Well, the actual example I was thinking of was the bailout of AIG, where certain creditors were treated differently than others, and some got paid 100 cents on the dollar and others didn't. And in the crisis of bankruptcy, the Indiana Pension Fund lost everything just because of the way the government played favorites. And that kind of favoritism is what's codified in the OLA Title II section of Dodd-Frank, and I think it's a very dangerous way. The old-fashioned way of doing it is the right way, a level playing field, everybody gets treated the same, and I wish we could get back to that. And I think there is legislation pending in the Senate, as I may have said in my testimony, proposed by Senator Cornyn and others, that would try to resurrect the historic bankruptcy principles.
Mr. Skeel?
So I do believe there were great problems with what was done in 2012. In 2008, Fannie and Freddie were taken over. They were put in conservatorship by the government. They were left there for a period of years, and lo and behold, Fannie and Freddie started to make money again. And so Treasury changed the deal and basically made it impossible for private shareholders to get anything. I'm not a constitutional law scholar, but it sure looks like a taking to me. There's some litigation on this. The plaintiffs lost one hearing, but there's some other litigation going on. The worst effect of this, in my view, is it has reduced any incentive for y'all to do something about Fannie and Freddie. As long as they're sitting there in limbo and they're making money, there's no pressure to fix them, and Dodd-Frank did nothing to fix them.
Thank you, Mr. Skeel. Thank you, Mr. Chairman.
Time of the gentleman is